Now, South Africa's exports to the United States worth billions of rands will be at stake if it fails to address some copyright concerns emerging in the US. They revolve around the generalized system of preferences under which certain items can be imported duty-free into the US. But countries must meet standards around labor rights, provide fair access to their markets in turn, and have effective intellectual property right protections to remain in that system. So it's a problem that is an emerging one. Ian Jacobsberg is a commercial law commentator. He joins us now just to make sense of this. Ian, thanks for coming in. Now, I thought it all started and ended with AGOA, the duty-free agreement that allows certain products to go into the US duty-free. What's this about?
Well, the GSP, the Generalized System of Preferences, is something that's actually quite a bit older than AGOA. It's been in place since the 1970s. AGOA was signed into force by President Clinton in around the early 2000s. The idea of it is that primarily developing African countries are given preferential rights. Their imports to the US are duty-free, provided, as you said, they meet certain standards. Now, what has happened over the last couple of years is that South Africa has introduced certain amendments to the Copyright Act and to the Performers Protection Act. The gist of these amendments, they're wide-ranging amendments. There's a vast range of amendments which we can go into, but this has raised certain concerns in the US, primarily on the basis that the intellectual property protection organizations in the US, and particularly an organization called the International Intellectual Property Association, has raised concerns that the amendments that South Africa is introducing are not in keeping with international standards.
Right. So, as I understand it, President Cyril Ramaphosa hasn't signed that as yet, but they're concerned about it. It ranges from things like movies coming in from the US, music, software, books. What exactly about the legislation that's yet to be signed are there concerns emerging from?
Okay, there are a number of concerns. If one starts with the Performers Protection Act, there the main concern seems to be that the period for which a licensee retains his rights. In other words, if a performer or the creator of a work enters into an arrangement with a publishing company, a record company, to publish their work, and on the basis of that they then sign their rights over to the company, and the company pays them a sum of money. Now, up to now, the period for which that assignment lasted could be up to 50 years. It's now been reduced to a maximum of 25 years. So the concern there is that the return on the investment will, for the investor, will be less.
Right.
So that's on the performance protection side. On the Copyright Act side, there are a number of things where they've introduced the principle of what they call fair use, where for certain public interest reasons, their copyright is made available on a compulsory basis, or a license is made available on a compulsory basis. In other words, that for educational purposes, for the use of disabled persons, there is this principle of fair use, where those people will be allowed to use it for those purposes.
And now, just to come in there, to interject in there, so essentially, I mean, just in practical terms, I mean, there were instances where you could lift up a song, for example, of the Beach Boys, just as a matter of concern, and then you could use that, but obviously, if it goes outside the time that you spoke about, let's say 50 years now, that's brought down to 25 years. Previously, you could use that willy-nilly. If the shelf life, for example, for lack of a better phrase, was longer. What you're saying now is that what the creative artists in the US are saying, look, we don't think there's enough protection in terms of that duration, for example.
Well, it's not the creative artists.
Yes.
It's the music companies who acquire the rights from the creative artists, who are saying, we are going to pay a certain sum of money on the assumption that we will own those rights for a period of time. Now that period of time is half as much as it used to be.
Yeah. What happens if we don't get the sign by the President or the changes in favor of what these companies want? Can we really see a threat to some of our exports there?
Well, it's a possibility.
Yeah.
I mean, the reality is, that legislation, particularly AGOA, was signed under a democratic administration who had probably a far stronger agenda to favor developing countries. The current US administration, as we now know, is far more business-friendly, far more capitalist-friendly, which, without commenting on whether that's a correct or an incorrect principle, their priorities are far more to favor the interests of US business. And therefore, those companies that will be investing and be paying for these works have now probably a stronger voice.
Yep.
And the priorities of favoring the developing countries are less forceful and less strong than they were.
Yeah, so we've got to watch out for the lobbying voice that could get stronger and stronger. Ian,
correct.
Thanks very much indeed. I'm afraid we've got to stop that because of time, but Ian Jacobsberg is a commercial law commentator. Thanks very much indeed for talking to us.
Thank you, Deb.